Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitutions. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
my Lord Mayor,
I think I have a right to raise those issues. I have a right to respond.
Just give
Mungai, Muigai.
I just wanted for good order,
okay.
my Lord.
Is that a clarification, Mungai?
Welcome to QNet's world of new beginnings, where every sunrise is a promise of our commitment to you, your health, your
Learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Muigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and as the court, I should be heard in silence. He will respond. And I indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. But under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lords, under the former constitution, under the former constitution, we used to have a practice in which we had an officially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my Lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My Lord, for purposes of Article 165, I believe it's 4 of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165, 4 of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
You apply that we discharge the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My lord, I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the 190 and with a clear conscience. 2 things. My lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lord, is this, the issue of bias. And this is biased by the Honorable...
I think, Mr. Mungai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that then does not have to do with those prayers. Well, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters, one of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is a right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see it, why I say this is important, is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So what, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I said down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My Lord, sir, just to add on what my learned friend has submitted on, I repeal.
With the permission of the presiding, I wish to say that I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
Senator Council Mute and Council Negua, you know, when you argue the way Mr. Mbe has argued, that court starts on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that courts start on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Murai. Let it not be an exchange between the court and yourself, because we are really very neutral party. Let us hear also from the other side.
We haven't really. In E015 in the report, the deputy president is the second respondent, first respondent. We haven't said our piece, and Elisha Ogoya will be making submission. But my Lord, do give us this very weighty matter. This E015 in Kilogoya. The orders of your brother, Mr. Justice Mungo, were given at 4 p.m. Why did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directions? How many times? permit us to articulate these issues for the sake of the nation. We are not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
There is no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call on any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the three files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4, on the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 plus 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated that 6 file with the lead file 522, have no reasons why they should be before you, noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission, for the record, Dr. Kamoto for the fifth respondent in Israel. I believe the reason we are here and the reason why we took forum is because we recognize that there are different parties to these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the audience of the court. So in this regard, my proposal is as follows, that each of the party whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectfully urge that we get an opportunity for each of the parties to ventilate the issues, because the fifth respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the nomination of a presidential and of a deputy president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
My Lord, for the fifth interest, for the first interested party.
Mr. Lord, just a minute. I was about to interject when Mr. When counsel, Mr. not the other one.
Rigathi?
Yes, was addressing. And that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which...
The application can only come after I have spoken.
We are now making an application, you respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165 Clause 4 to empanel this bench. Your Lordship, this is the background of my application. That on the 14th of October, the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 546. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is Muzomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not productive. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes,
my lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you are being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, Ndegwa and my friend Kibe, is that you are taking the court for a long ride and we are ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say?
My Lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your Lordship's stand. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My Lords, if it pleases the court, my name is Milimani. I am acting in person. We filed an application for a certificate of urgency on the 8th of October, 2024. Before this bench was in panels on the 14th of October, 2024. Unfortunately, some of the parties we were seeking have been overtaken by events. My Lord, and today, as the part of our application has not been placed before you, and we are just concerned that our application will once again overtake our application. My Lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my Lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, can I just be heard for 1 minute only? My Lord Judge asked an important question. How do we move forward? But the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Grima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We add that you give direction in the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that suit, in accordance with my teacher's guide and Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that Mr. Boy applying for an adjournment? Because he's saying, and perhaps it's wrong, that even the recusal application comes after the termination of the question on panel. If that be so, and they may leave, they normally leave court, they left Senate, may leave court, let them say whether they are applying for adjournment.
Is that the mark they normally leave court where the left Senate palatable in this court, my Lord? I need that.
No, because it's an adjournment.
No, is that the mark palatable for my Lord and my Lady? But because, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a vain application for adjournment. Because Mr. Ward is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but he did withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
Lawyer, I have no problem withdrawing. Okay, my friend, no, I have no problem, my lord. I withdraw the remark, but
Thank you.
there is practice.
Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Gibe Mungai, and learned colleague, Mr. Njegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that regard that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gibe again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Again, on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light, which is now. They actually knew of it, and this, or should have, they would have found out. The letter, which was written this morning, which we have, it was received on the 20th, the 20th of October, has actually one pertinent question disposed, whether the file was actually taken to the Chief Justice and at what time. So, they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to ECJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. That as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they're trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue when the Chief Justice, Deputy Chief Justice sat, does not arise. As to what happened on Saturday, again, this is purely administrative.
My Lord, for the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
How we deal with death isn't just personal, but also cultural. For many around the world, honoring the dead can be a daily event with offerings and altars at home. Tech companies are creating digital options for these things. For example, a digital likeness in the metaverse that lives on forever. We've met someone that wants just that. Nicole Stacke loves life in the metaverse. Here she can meet friends and explore the world. And for when she passes away, Nicole imagines her avatar living on here.
Tu na ni ile hali ya mawakili kutoka pande zote kuweza kujadiliana ama kuweza kuleta kesi yao mbele ya mahakama na pia kupeana maoni yao na pia kuuliza maswali ambayo kwangu mimi naona ilikuwa tu sawa. Lakini pia nimeona kama tungeendelea vile kila wakili wa pande hii na pande nyingine kuwa anauliza maswali kiasi cha yale maswali ambayo tumeona yakiwa yakitoka kwa mawakili wa aliyekuwa naibu wa rais, basi tungekuwa na siku mzima labda ya kuuliza maswali. Nimefurahishwa sana na jaji mkuu na jaji mmoja Ogola ambaye ameweza kupeana mwelekeo sasa kuwa watarudi, wataenda wajadiliane na pia watarudi sasa ndio wapatiane mwelekeo kuhusu hii kesi. Lakini ukiangalia maswala ama mambo ambayo yalikuwa yameletwa na mawakili wa aliyekuwa naibu wa rais, kama kusema naibu wa Chief Justice Madam Mwilu kuwa hangeweza ama hakuwa na hajafikisha kiwango cha kuteua ile benchi ya majaji watatu. Umeona tumesikiza kutoka kwa Wanyama, na pia nafikiri huo ndio msimamo wangu pia, kuwa ni kweli eti Mwilu ndiye msaidizi mkuu wa jaji mkuu wa mamlaka yetu wa mahakama, na kwa hivyo kama jaji mkuu hayuko, basi naibu wake ambaye ndiye pia msaidizi wake anatosha kukuwa akiweza kupeana ama kutengeneza hilo jopo la majaji.
Naam. Na Steven, tumeona wakienda hapa kule, wanaenda huko, wanarudi huko. Je, katiba haipo wazi kwamba ikiwa jaji mkuu hatakuwa na nafasi pengine hiyo siku ya Jumamosi kuweza kuunda hilo jopo, basi msaidizi wake angefanya hivyo, ambapo hilo ndilo lilofanyika?